Welcome to our presentation on student rights and restrictions. Topics will include dress and appearance, search and seizure, cell phones, due process, freedom of expression, classroom harassment, corporal punishment, and discipline. Rights of expression include freedom of speech, freedom of press, and freedom of assembly and association. In short, the key provisions of the First Amendment in the Bill of Rights of the U.S. Constitution. A case that involves rights of expression is Pickering versus Board of Education. Pickering involves a teacher who is dismissed from their job for sending a letter to the local newspaper that had something to do with the school board. Both the school board and the lower courts said that in the letter it contained false statements, which was important for the school system not to include. The school wanted precedence over the teacher's claim to freedom of expression, but the Supreme Court ruled that it was wrong that the school board fired the teacher. Freedom of expression refers to the ability of an individual or group of individuals to express their beliefs, thoughts, ideas, and emotions about different issues. This is, of course, free from any government censorship, but this is different in schools, however. Teachers and students have different rules that they need to follow. When speaking about expression within the school, there are 3 different topics to cover: expression outside the classroom but on school grounds, classroom academic freedom, and retaliation for speaking out about suspected wrongdoing. Next, we will be discussing dress and appearance. What is a dress code, and what is the difference between a dress code and a uniform policy? Dress code refers to a set of rules about what clothing may and may not be allowed in a school. Dress code is more of a guideline, while a uniform policy is more of a set of rules where you must follow them. Dress codes just give the students an idea of what not to wear, while uniforms are what you must wear. State law does not give the students the right to choose their mode of dress. This is up to local school districts. Any limits on this? Tinker versus Des Moines School District is a case where schools must be careful not to intrude upon the subject of symbolic expression. This case included a study on armbands that students were wearing that were to protest the Vietnam War. As long as it didn't cause any material disruption or interfere with the rights of others, the case ruled that this was justified. In Carr versus Smith in 1972, elementary and secondary schools did not have any grooming rights, which meant that the school or the kids themselves did not have the right to choose their dress code. While in Lansdale versus Tyler Junior College in 1972, at the same time as this other case, we move to a college setting where you have your own rights along with your high school diploma. So basically, in this case, what had happened was that Joe Richard Lansdale and 2 other men attempted to register for the fall 1970 semester at Tyler Junior College, but because of their hairstyles and them not conforming to a particular section of the dress code, they weren't allowed into the school or to register. So by this, the schools eventually appealed because holding that at a college level, such interests are not sufficient to warrant a similar intrusion on the liberty interests of college students, as they are for elementary schools and or secondary schools. Next, we will be discussing search and seizure and cell phones. Search and seizure is a procedure used by officials to find evidence connected to a crime or offense by someone who they feel could be connected by something in their personal belongings. A lawful search and seizure includes 2 things: establishing reasonable cause for believing students could be violating or have violated a school law or policy, and they must ensure that the search is reasonable based on age and sex of the student and the nature of the offense. Some notable cases to mention are New Jersey versus TLO, where the court rejected the idea that school officials could take the place of the parent during a search and had the same authority. This is called loco parentis, where another official can take the placement of the parent. The U.S. Supreme Court ruled in 1985 that the 4th and 14th Amendment also applied to public school students. The 14th Amendment grants citizens equal protection under the law, while the 4th Amendment prohibits unreasonable search and seizures. Some other important cases to look at are Coronado versus State, where there was an unreasonable search after a student had lied about his whereabouts and was told to remove his clothing during a search, where they found nothing. They continued to search his car, found nothing, including his locker as well, found nothing, and the court ruled it as too intrusive towards the end. There are some cases where the student refuses to comply to the search and seizure. In this case, you want to involve parents and or the police, so that way the student is more willing to agree to the search. When speaking about locker and desk searches, you must be aware that they are jointly held property of the school. So in that case, in the case of Shoe versus State, a student had been in the presence of the vice principal, to which then her purse went missing, and this student already had a history of theft. The court then ruled it just that the vice president wanted to look into the student's locker because the locker was part of the property of the school, and the history of the student made sense for the search. Cell phones can be included as a small part of the search and seizure. This policy is required if a cell phone must be searched or is found. The rules for cell phone search are the same that are applied to the search and seizure. It must be treated the same, just as normal search and confiscations must be justified. They cannot be searched without reasonable cause, and a notable case to think of is Clump versus Nazareth. This is a Pennsylvania case involving a phone being confiscated, and then 9 students on that list of contacts on the phone were called to determine if they were also breaking this cell phone use policy that was present in the school mentioned. This was not a justified action, and it violated the 4th Amendment.
The 14th Amendment provides that no state shall deprive a person of life, liberty, or property with due process of law. In short, due process of law is a means of assuring that decisions made by government officials affecting people's essential rights are made fairly. Since the Constitution only restricts governmental action, the Due Process Clause is not invoked in the private sector. Before any process is due, however, there must be 1. State action, and 2. Deprivation of life, liberty, and/or property. Currently, there is no known instance of any school district taking an individual's life, so for practical terms, the focus here is going to be on the deprivation of liberty and/or property. Some notable court cases that involve due process include Board of Regents versus Roth in 1972 and Stratton versus Austin ISD in 1999. In the former, the Supreme Court ruled that teachers have a protectable 14th Amendment property right in continued employment if state law gives them a legitimate claim of entitlement to it. And so, we have to look at state law to determine what that legitimate claim is. For context leading up to Stratton versus Austin ISD, allow me to share some more notable pieces of information. In Texas, the general rule is that an employee works at will unless a contract of some sort says otherwise. For constitutional purposes, at-will employees have no constitutional right to their position, and so early termination of their work is not a deprivation of property. It is also important to note that non-renewal of a term contract is also not a deprivation of property, since, for all intents and purposes, once your contract has ended, your position is no longer your property. All of this leads us to Stratton versus Austin ISD. In 1999, a non-renewed teacher complained when the school board limited her hearing before it to a 1-hour presentation. The teacher claimed that this violated her due process rights, but the court easily dismissed this argument, noting that the language in the Education Code supersedes earlier court cases and that she has no property interest under Texas law. And thus, it is clear under Texas law that educators have a property right subject to protection under the Due Process Clause when the district seeks to terminate a contract prior to its stated ending date, but not when a district chooses not to renew a contract that has run its course. Next, we will discuss classroom harassment. It is important to note that the term harassment used in society is not the same as what the law defines to be harassment. Legally speaking, harassment is defined as unwelcome verbal or physical conduct based on a protected class, be it race, color, religion, sex, national origin, disability, or even age. There is also a distinction when harassment is illegal or legal, since the anti-discrimination statutes are not exactly a code of civility. Harassment becomes illegal when the conduct is pervasive or severe enough to create an environment that a reasonable person would consider intimidating, hostile, or abusive. The law does not prohibit meanness, simple teasing, or isolated incidents, and permits behavior that is not based on a protected class. This means legal harassment from members of the same class could be considered equal opportunity jerks, which is not exactly a crime. One notable court case focused on harassment is Lovins in the United States versus Pleasant Hill Public School District. In this case, the section intervened in the same-sex harassment case, alleging the school district violated Title IX of the Education Amendments of 1972 and the Equal Protection Clause of the 14th Amendment by failing to respond appropriately to a harassment of a student on the basis of sex. Specifically, from the 8th grade through the 11th grade, Jeremy Lovins was subjected to harassment of the basis of sex, ostensibly because other students believed he was gay. Jeremy and his parents repeatedly informed the school officials of the harassment, but it continued, and Jeremy was eventually subjected to an assault and forced to leave the school because of the harassment he has been enduring. On July 31, 2000, the court entered a consent decree settling the case. Under this decree, the school district agreed, among other things, to conduct a climate assessment of student-to-student and teacher-to-student relations within its schools, to develop a comprehensive plan to identify, prevent, and remedy harassment and discrimination on the basis of sex and sexual orientation, to educate and train teachers, staff, and students about the operation of the policy and procedures to maintain written records of complaints and investigations, and to file implementation reports with the section and the court. Finally, we'll be discussing corporal punishment and discipline. Corporal punishment is punishment intended to cause physical pain to a person. When practiced on minors, especially in home and school settings, methods include spanking or paddling. In Texas, corporal punishment remains legal and is one of the few areas where local control truly exists. There is no state law regarding corporal punishment, and therefore all decisions about this practice are left to local school offices, where some have banned them outright or restricted in various ways. In the case of Ingraham v. Wright, the court ruled that corporal punishment of public school students, 1, did not require any formal due process measures, and 2, under no circumstances could be considered cruel and unusual punishment, as the term is used in the Eighth Amendment. In effect, the Supreme Court left the regulation of corporal punishment to state and local officials. Litigation over the practice continued, of course, such as in the case of Flores v. School Board of DeSoto Parish, where a teacher used physical force with a student, but the parties characterizes the incident differently. The parents said it was assault, while the teachers said it was corporal punishment. The court concluded that the allegations amounted to a claim of excessive force, which could be redressed under the state of law of Louisiana, and were promptly dismissed. This is typical, where the federal courts clearly prefer that claims involving corporal punishments should be addressed through the state courts, rather than morphing into constitutional issues for the federal courts to set out. Another example of this preference can be seen in the case of Cosby v. Groveton, where the parents sued the school district and 2 school employees who had paddled their son. The federal court noted that Texas law, like Louisiana law, offered recourse for the excessive use of force and to refile in a state court.